Bonjour. Vais-je avoir l'honneur de présenter mon petit discours en français? No, I think I have to continue with the same line and with the same language, even if it was the real English. Okay, the question was actually court procedure and pre-trial motions. When I was preparing this slide this morning, I actually read the criminal procedure law, Rwandan criminal procedure law, because the Rwandan criminal procedure law is the one. Okay. Hello? No, it's not. Rwandan criminal procedure law is the law that governs how the criminal trial, how the criminal proceedings have to be conducted. So it is my duty to say that what I'm going to present as motions here concerns only motions that can be raised in criminal trial, not in civil matters. I know you have so many motions that are used to raise up before judges in civil matters, administrative, and etc. Mine concern only in criminal matters, because I do not say that there is no human right in civil matters, there is no human right in administrative, in other matters. There are. But the one I have been asked to present concerns only motions that can be read by lawyers in the interest of the client in criminal matters. First of all, I have to say that how important are criminal proceedings? They are important. Why are they important? They are important because they are for public interest. That's why I think we have a very key provision in criminal procedure law stating that all issues concerning jurisdictions are for public interest. I think you know the provision that is very, it's not contentious because of public interest, because even if the party want to waive that, it cannot be accepted by the court because it's for public interest, especially jurisdiction concerning ration materiae. These are Latin terms, ration materiae, ration loci, ration personam. These are for public interest. Parties have to be bound by that. That's why I'm saying in this slide that the main aim of procedural criminal law is to regulate how these different acts must be done in a way that does not violate the right of the accused persons. Just an example, that the party have to respect what the law has said that have to be done in the process of the criminal trial. Imagine for example, if the police, an investigator, a RIB agent, who had the right to search suspect house without any limitation being to put in this right. He comes in midnight, he comes 2 a.m. or 3 a.m. and he knocks in your house and you open and he goes in, and you understand how it is very, very serious in criminal, in human rights perspective. This could be obviously to horrible abuses and unintended consequences. Without police officers knocking your door in the middle of the night and without a reasonable reason to search your house. So before coming in somebody's house to make search, you know that the law has provided some legal safeguards. For example, the legitimacy. There might be a reason to come to search in your house. Otherwise, it will be the domicile violation that we know. It is very, very interesting. The right to privacy is very key. It is a fundamental right. Supposed to violate your domicile right, your privacy, there might be a very, very legitimate reason or genuine reason. So who ought to do what? It's very interesting. In this law, criminal procedure law, citizens have to protect against other citizens from infringement or other rights. In particular, under the influence of the human rights discussion, one has come to realize that criminal law not only governs the behavior of ordinary citizens, and therefore not only aims of protecting citizens against violation of the right by other citizens, it also governs the behavior of the people who are responsible for the maintenance of the law: police, prosecutors, judges, prison wardeners, in short, the criminal justice system itself. So the law governing criminal procedure law does not only concern accused, suspect, etc. Also, I remember one day, it's even very recent, it was last week, I was a defense case, I was a defense lawyer in a criminal case, whereby the prosecutor used to say, Mr. President, the criminal did this, the criminal, Mr. President. I say, no. Objection, Mr. President. How can the prosecutor can violate in front of you, before judges, saying that the criminal, and he still had the right to be presumed innocent. And that is going to create in the mindset of the public in courtroom that my client is a criminal. And I know at the end of the process, Mr. President, you are going to find that he is innocent. So please, can you tell him that he has to say, we are suspect, we are thinking he is, because he has to be, and I quote the famous case of Alain de Ribemont in European Human Rights Court that said even judges, prosecutors, police, they also have the burden, they have the duty to, even during the trial itself, to respect and implement the right to presumption of innocence. So it concerns everybody from A to Z. From A to Z, everybody is il est débiteur du droit de la présomption d'innocence de l'accusé. In short, the overreaching goal of the criminal law is to make clear to citizens in general which behavior they have to be different from them, but to criminal justice system to the boundaries of the power or they are. You know that states are actually the main violator of the rights of the citizens. So if we lawyers, we don't say, you public prosecutor, you did this, you violate this, so there is no one who is going to do that on our behavior. So because if actors, when I say actors of a criminal process, lawyers, judges, police, investigators, do not respect the human rights procedures, the human rights as specified in the constitutions, all the values, all the social values in the society are going to be undermined. And that's very, very key. So it is very important for us to raise motions if we think they have link with the rights of our clients. So I have found that in a criminal procedure law, there is some motion that you may raise before even the case being transmitted to the competent court to be heard on the merits. So some of them may be raised before the prosecutor, others may be raised during the trial phase. So here I was actually requested to talk about the pre-trial motions. By pre-trial, I have understood that it is all these procedures or proceedings that have been carried out by the prosecutors until the case is going to be heard on its merits. So until the beginning of the trial phase. Issues concerning pre-trial detention, according to me, it is a pre-trial, even if it is going to be carried out before the judge himself. So in Rwandan context, it is a judge, not investigative judge. So here, one of the important things is actually what we call pre-trial motions. We do have very important phase, very important proceeding in civil matter, what we call pre-trial conference. What we call in French, la procédure de mise en état. You know that mise en état or preparatory conference between parties in criminal matter does not exist. So it only occurs in civil matters. I used to say that it is more important in criminal matters than in civil matters. But we don't have it. Is it possible to have a preparatory conference in criminal matters? And I say yes. Why can't you come before the judge who should have been called? Le juge d'instruction, why not? and saying, I'm going to these evidences, I'm going to say these evidences, but I'm going also to challenge the evidences you have brought before the judge because they are illegal, and then actually being prepared and writing motions before. My time is over? No. Yeah, so being prepared that you are going to actually to raise some motions before the judge and actually making them in writing. Just not letting before the hearing, Mr. President, I have a motion. Mr. President, I have an objection. Mr. President, you don't have a jurisdiction. You don't have a jurisdiction? Yes. Or Mr. President, I disqualify you because you are, because you did this, you got that. What used to say? If it has to be done before, you understand it can actually ease the process and it is on the benefit of our clients in normal circumstances. So, having said that, the fact that we don't have the pre-trial conference in criminal matters brought very important things that we have to be prepared during the hearing on the merit of the case. But one more important thing that I may say it is the very, very important motion that lawyers, defending lawyers in criminal matters, it is actually the release on bail. The motion concerning release on bail. I'm saying, maybe you are going to say it's not a motion. In Rwandan context, motion being an issue, a legal issue that you raise to somebody so that it has to be ruled before you go further in the case, according to me, it is a motion. Because the law says, in Rwandan criminal procedure law, you may request the release of your client even before the prosecutor. I think it is Article 105. The law says, 105 of this law, I'm going to show you. No. Motion of release. No, it is motion of release to the prosecutor. The public prosecutor shall examine the application for provisional release if it is still investigating the case. The case file has been already transmitted to the court, whether the stage of the provisional detention hearing or at the stage of the hearing on the merit. The application shall be examined by the court. So the release on bail can be raised before the prosecutor or before the court himself. When the case is still under investigation, it is up to us, advocates, to raise before the Mr. President, Mr. Prosecutor, please, why do you think it is very important to detain my client? And it's very easy to investigate it while he enjoys his freedom, and actually it is the principle, except it is a detention. So it is up to you to say that. But when the case has been transmitted to court, especially on the issue concerning its detention, it is once again up to you to raise it when during the pre-trial detention proceeding. It is not forbidden, it is even allowed by Article 105 to do it even if the case is going to be heard on its merit. It is very important. The release, the provisional release, is actually allowed to be raised at any time. That's why, by saying that, I'm going to say this. Some motion may be raised in liminalities, or they may be raised up at any level of the proceeding. Even if you did not say that, it is not forbidden for you to raise a provisional release even if you are at the level of appeal. It's not forbidden. Because it is not going to hamper, it is not going to jeopardize the proceeding on the merits of the case. So it is allowed. What has to be respected, it is actually what I have found in Article 150. Substantial principle of criminal cases. It is both for the trial on merits and for both the trial en rapport avec la détention provisoire. Excuse me, sometimes my French comes very quickly than the English word. In the public prosecution found that there is no reason to prosecute the suspect held in the provisional detention. It must apply for his release. Actually, that is actually what we used to call in common law system, and Jacques knows that better than me, what they call the proceeding of nolle prosequi. Nolle prosequi Latin, because I did Latin, I understand what it means. It means sometimes prosecution may come and say, Mr. President, we are no longer interested by prosecuting this guy, so we dismiss all charges against him. It is very rare in Rwandan context. It's very rare. On contrary, we used to understand the maxim calling that la plume est sage, mais la parole est libre. That is not the dismiss of the charges. So coming before judge saying, we do not have any case against him, please dismiss it. It's very rare in Rwandan context. But indeed it is, when you understand the article 150, no, 120, let me show you, sorry. This one. People understand that nolle prosequi ou la main levée de la détention provisoire comes only in the case of pre-trial detention. When you read conjointly Article 150 and 120, so nolle prosequi may even be raised during the trial phase. Because the case says, the law says 150. Who? If the prosecution found that there is no reason to prosecute, the statute has in provisional detention might apply his release. Who is going to apply for the release of the accused? Here it is the prosecutor. And according to me, that is nolle prosequi proceeding. So it is allowed. So please, when you think there is no reason to prosecute your client, for example, if your client has paid the fine without trial, if your client is going to be tried twice, non bis in idem, if your client has actually been convicted for that, please, res judicata, le principe de la chose jugée, you may raise it everywhere. But for the good administration of the justice, which we also have the duty to observe, it's very important you say in liminalities. You say before the court goes further. Mr. President, how can you judge my client and he has already been convicted for that, or he has been tried for that, he has been acquitted for that? So the issue concerning the motion that have to be raised in liminalities, it is you as a lawyer, in the interest of your client, to know when I'm going to raise it. So the issue of timing. Timing, it is up to you to decide what is the timely motion and when. So it is to you. So what I'm going also to say is actually principles that have to govern. I'm coming, Mr. Bagabo. The issues 153, I hope I have written it, 153.